Hello and namaste to all of you. Today in our UPSC GS series under sustainable development, we are doing unit 9 state initiatives. Under state initiatives, we have to cover introduction, legislative measures, judicial measure interpretations, institutional mechanisms and summary of the state initiatives. The general instruction for the students are the same, and that is they have to listen very carefully and with intuition the full audio number 14 state initiatives of the sustainable development and note down 10 words, and that words must be important for them in their notebooks. Now we are beginning. Number one, introduction. The goal of environmental protection seems to be high on India's priority list, going both by its participation in international efforts as well as by its efforts within the country. India has participated actively in international environment conferences and had signed and duly ratified most of the important conventions relating to environmental protection, thereby taking on international legally binding obligations in this direction. It has enacted a large number of environmental laws within the country, covering almost every sector of the environment. What is more, the Indian judiciary has taken the issue of environmental protection very seriously and through expansive interpretation has ensured for all practical purposes a right to environment. There is also in place in India an institutional mechanism to take care of environmental issues. In real terms, however, it has not been easy to translate these initiatives effectively into reality. There are numerous problems in implementing this large body of law. Point 2. Legislative measures. An amendment to the Indian Constitution inserted in 1976 provisions relevant to environment protection. Article 48A was added in Part 4 of the Constitution, Directive Principles of State Policy, calling upon the state to protect and improve the environment and to safeguard the forest and wildlife of the country. Also, Article 51AG was inserted, imposing a fundamental duty on every citizen to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures. Along with the constitutional provisions, there are numerous acts, rules, and notifications dealing with different aspects of the environment. The Indian Penal Code IPC 1860 has a number of provisions that can be invoked in the context of environmental litigation. Section 268 of IPC defines public nuisance as an act that causes any common injury, danger, or nuisance to the public or to the people in general who dwell or occupy property in the vicinity or which must necessarily cause injury, obstruction, danger, or annoyance to persons who may occasion to use any public right. Various other provisions of the IPC can also be invoked for environmental matters. Besides these provisions, however, there is an entire body of enactments numbering close to 200 that are directly aimed at environmental protection. Some of these are listed in the table followed by a brief description of some of the important enactments. Environmental legislation in India. Indian Forest Act 1927, Wildlife Protection Act 1972, Wildlife Transactions and Taxidermy Rules 1973, Wildlife Stock Declaration Central Rules 1973, Wildlife Protection Licensing Additional Matters for Consideration Rules 1983, Water Prevention and Control of Pollution Act 1974, amended in 1988, Water Prevention and Control of Pollution Rules 1975, Water Prevention and Control of Pollution Cess Act 1977, amended 1992 and 2003, Water Prevention and Control of Pollution Cess Rules 1978, Forest Conservation Act 1980, Air Prevention and Control of Pollution Act 1981, amended in 1987, Air Prevention and Control of Pollution Rules 1982, Air Prevention and Control of Pollution Union Territories Rules 1983, Environment Protection Act 1986, amended in 1991, Environment Protection Rules 1986, Hazardous Waste Management and Handling Rules 1989, Manufacture, Storage and Import of Hazardous Chemicals Rules 1989, Manufacture, Use, Import, Export and Storage of Hazardous Microorganisms, Genetically Engineered Organisms or Cells Rules 1989, Public Liability Insurance Act 1991, Public Liability Insurance Rules 1991, Coastal Regulation Zone Notification 1991, Environmental Impact Assessment Notification 1991, Environmental Audit Notification 1992, Environmental Standards Notification 1993 and 1996, Environmental Clearance Notification 1994, National Environment Tribunal Act 1995, Wildlife Protection Rules 1995, Wildlife Specified Plants Conditions for Possession by License Rules 1995, National Environmental Appellate Authority Act 1997, Biomedical Waste Management and Handling Rules 1998, Ozone Depleting Substances Regulation Rules 2000, Biodiversity Act 2002, Water Pollution. The Water Act of 1974 established an institutional structure to oversee and ensure the prevention and abatement of water pollution. The Act set up the Central Pollution Control Board (CPCB) and State Pollution Control Boards (SPCBs). As per the Act, any person who knowingly causes or permits any poisonous, noxious, or polluting matter to enter water bodies in violation of stipulated standards is guilty of an offence which attracts penalties laid down in the Act. The water rules were enacted in 1975, containing schedules and forms of information to be furnished by industries. The Water Cess Act of 1977 provides for the levy and collection of cess on water consumed by certain industries. These resources are used for prevention and control of water pollution. The standard forms and schedules for the supply of information are prescribed in the Water Cess Rules of 1978. Air pollution. The Air Act of 1981 entrusts the power of enforcing its provisions to the CPCB. In fact, the Air Act is to a large extent a mirror image of the Water Act. The objective of combating air pollution under the Air Act is undertaken by means of declaration of restricted areas, prohibition of use of polluting fuels and substances, etc. The penalties detailed in the Act are similar to those in the Water Act. The air rules were adopted in 1982. Environmental protection. The Environmental Protection Act (EPA) of 1986 is an umbrella legislation with wide legislative coverage. It gives wide powers to the central government to take all such measures as it deems necessary to expedient for the purpose of protecting and improving the quality of the environment. Such measures include laying down standards for environmental quality, restricting areas of industrial operations, laying down procedures for handling hazardous substances, etc. The central government can close down offending industries and restrict the setting up of new industries at environmentally non-compatible sites. The environment rules of 1986 lay down procedures for the setting of emission and discharge standards. A host of notifications have been enacted under the EPA, such as those on environmental impact assessment and coastal regulation zones. Hazardous substances. There are various enactments relating to hazardous substances. The Hazardous Waste Rule of 1989 make generators of hazardous waste responsible for proper handling and disposal of such wastes. There are also rules aimed at protecting the environment and human health from potential adverse impacts of gene technology and microorganisms, which set up a network of committees to regulate animal pathogens, plant pests, and genetically modified organisms. The hazardous chemicals rules of 1989 set up an authority to inspect industrial activity connected with hazardous chemicals. The Public Liability Insurance Act (PLIA) of 1991 deals with accidents involving hazardous substances and insurance coverage. In case of death or injury from an accident, the owner is made liable to provide relief as specified in the Act. The Public Liability Insurance Rules of 1991 lay down the standard administrative procedures for seeking relief. Forests. The legal regime to govern forests reflects the dual relevance of forests from the ecological and the economic points of view. The Indian Forest Act (IFA) of 1927, which is a product of the colonial times, reflects a revenue-oriented policy. It mainly regulates dealings in forest procedure and facilitates the levying of duties on timber. This act authorities the state government to constitute any forest land or wasteland as reserved forests by notification, thereby acquiring proprietary rights over the forest, and forest produce activities in a reserved forest are regulated by the government. The Forest Conservation Act (FCA) of 1980 focuses more on the ecological value of forests. It lays down that no state government or other authority can, without the prior approval of the central government, make any order to de-reserve forests, use any forest land for non-forest purposes, lease out forest land to a private agency, or cut naturally grown trees in forest land for the purpose of reforestation. The state government may seek such permission only after considering all alternatives and finding that no other alternative is feasible and that the required area is the minimum needed for the purpose. FCA therefore brings all forests in the country under the overall guardianship of the central government. Wildlife. The Wildlife Protection Act of 1972 (WPA) provides for the regulation of hunting or killing of scheduled animals and protection of specified plant species. It confers powers on the state governments as well as the central government to proclaim sanctuaries and national parks in order to protect wildlife. The WPA, that means Wildlife Protection Act, along with its various amendments, covers various issues such as regulation on hunting of wild animals, possession of animal trophies, and other products, setting up of central zoo authority, etc., and sets out a framework for punitive action in instances of violation. A number of specific rules have been issued under the WPA. Biodiversity. The recently adopted Biodiversity Act 2002 aims to provide for conservation of biological diversity, sustainable sustainable use of its components, and fair and equitable sharing of the benefits arising out of the use of biological resources. Knowledge. The Act provides for the constitution of a National Biodiversity Authority at the national level, state biodiversity boards at the state levels, and biodiversity management committees at the local levels to implement the provisions of this Act. Policies. Apart from the above mentioned legislation, numerous policies have been formulated by the government to further the objective of environmental protection. These include the National Conservation Strategy and Policy Statement on Environment and Development 1992, the Policy Statement for Abatement of Pollution 1992, the National Forest Policy 1988, and the Wildlife Conservation Strategy 2002. India has a fairly good record of participation in international efforts at environmental protection, having ratified over 40 multilateral environmental agreements (MEAs) relating to various components of environmental protection. Some of the major areas of environmental protection that India is active in at the international level are listed in the table. Apart from its signature and ratification of almost all the major MEAs, India has also made its presence felt in all major international conferences relating to environmental protection and sustainable development. Table. India's participation in multilateral environmental agreements. Serial number 1 is issue area. Protection of wetlands. International legal instrument. Convention on Wetlands of International Importance, especially as Waterfowl Habitat 1971. Date of signature not known. Date of ratification 1/10/1981 A. Serial number 2. Issue area. Protection of heritage. International legal instrument. Convention concerning the protection of the world culture and natural heritage 1972. Date of signature not known. Date of ratification 14/11/1977. Serial number 3. Protection of endangered species. International legal instrument. Convention on international trade in endangered species of wild fauna and flora 1971. Date of signature 9/7/1974. Date of ratification 27/1976. Serial number 4. Conservation of migratory species. Protection of the ozone layer. Convention on the Conservation of Migratory Species of Wild Animals 1971. Vienna Convention for the Protection of the Ozone Layer 1985. Montreal Protocol on Ozone Depleting Substances 1987. Date of signature 23/6/1979. Date of ratification 4/5/1982. Vienna Convention for the Protection of the Ozone Layer 1985, 18/3/1991, and Montreal Protocol on Ozone Depleting Substances 1987 was signed on 19/6/1992. Number 6. Protection from hazardous wastes. Basel Convention on Transboundary Movement of Hazardous Wastes and Their Disposal 1989. Date of signature 15/3/1990. Date of ratification 24/6/1992. Number 7. Preventing climate change. International Legal Instrument, United Nations Framework Convention on Climate Change 1992. Date of signature 10/6/1992. Date of ratification 1/11/1993. Kyoto Protocol in even FCCC 1997. Convention on Biological Diversity 1992. It was serial number 8, Conserving Biodiversity. Also, Cartagena Protocol on Biosafety 2000. Signed on 5/6/1992. Ratification on 18/2/1994. Number 9. Combating desertification. International Legal Instrument Convention to Combat Desertification 1994. Signature on 14/10/1994. Ratification on 17/12/1996. Serial number 10. International Legal Instrument Protecting the Antarctic Environment. The Antarctic Treaty 1959. Signature not known. Ratification not yet. Number 11. Preventing marine pollution. International Legal Instrument Convention on the Conservation of Antarctic Marine Living Resources 1980. Protocol on Environmental Protection to the Antarctica Treaty 1991. Convention for the Prevention of Marine Pollution by Dumping from Ships and Aircrafts 1972. MARPOL. Protocol relating to International Convention for the Prevention of Pollution from Ships. United Nations Convention on the Law of the Seas 1982. Protocol on Environment Protection to the Antarctica Treaty 1991. Signature on 2/7/1991. Ratification on 26/4/1996. United Nations Convention on the Law of the Seas 1982. Signature on 10/12/1982 and ratification on 29/6/1994. Judicial Interpretations. Point 3. Judicial interpretations, a major initiative towards environmental protection and sustainable development in India, has originated from the Indian judiciary. The commitment of the judiciary towards social good in general and environmental protection in particular led to the emergence of the innovative use of public interest litigation (PIL) as a tool for social and environmental justice. The judiciary has contributed to environmental protection in India in two ways. It has introduced procedural innovations to provide much wider access to justice, and it has, by a positive and expansive interpretation of the right to life enshrined in Article 21 of the Constitution, included within its ambit a right to a healthy environment. As pointed out above, the Indian Constitution does not provide a distinct fundamental right to environment. Environment finds mention only in the directive principles and fundamental duties. However, the Indian judiciary, starting from the 1980s, has adopted an increasingly environment-friendly stance and has imparted an interpretative linkage between a clean environment and the right to life. The judiciary in various cases has held that the basic requirement of a decent quality of life is to live in a healthy environment. The right to environment was given judicial recognition in the Dehradun Lime Quarries case, Rural Litigation and Entitlements Kendra versus State of Uttar Pradesh 1987 and reaffirmed in the Sri Ram gas leak case MC Mehta versus Union of India 1987. The judiciary has also dealt increasingly with cases involving a reconciling reconciling of environmental goals and development imperatives. In most such cases, the Indian courts have held that while the significance of development imperatives cannot be denied, environmental protection is a larger good that is worthy of pursuit even at the cost of short-term losses such as loss of jobs or revenue. Some of these cases are briefly described in this section. Dehradun Lime Quarries case 1987. This case related to a stone quarrying operations in the Doon Valley, which the petitioners claimed represented ecological havoc for the hills in the region. The Supreme Court ordered the closing of the mining operations in the areas where mining was reported to be dangerous, even in the face of the hardships caused to the miners. Considering this, a price that has to be paid for protecting and safeguarding the right of the people at large to live in a healthy environment. Of course, the court directed that the workers of the mines were to be rehabilitated through re-employment in reclamation, afforestation, and soil conservation programs in the areas. In this case, the Supreme Court came to its conclusion after having weighed the environmental need to protect the ecology of the hills against the need for limestone quarrying for industrial purposes in the country. The court acknowledged the importance of industrial development but declared that it was not to be achieved at the cost of creating an ecological imbalance. Also, the Supreme Court spoke of a right to environment in this case. Sri Ram gas leak case 1987. In the Sri Ram case, the court ordered the closing down of hazardous industry wherein a gas leak had caused the death of a worker and endangered the health of several others. The court held that the state had the power to restrict hazardous industrial activities for the purpose of protecting the right of the people to live in a healthy environment and let down conditions under which industries of hazardous products would be allowed to restart. In this case, the court evolved the principle of absolute liability of compensation through interpretation of Article 21. Further, it held that the right to life contains the right to claim compensation for the victims of pollution hazards. Ganga pollution case 1988. In the Ganga pollution case, the Supreme Court issued directions to numerous tanning and therefore polluting industries located on the banks of the river Ganga to either set up effluent plants or close down. It also ordered close to 5,000 industries located in the Ganga basin to install effluent treatment plants and air pollution control devices. The court also issued directions to the central government, Uttar Pradesh UP Pollution Control Board, and the district magistrate to ensure implementation of its orders. Again, the judgment was written taking into account the fact that the closure of the tanneries might result in unemployment and loss of revenue, but the court held that the life and health of people and the ecology of the Indo-Gangetic plain were more important. Stone Crushers Case 1992. The Supreme Court in this case ordered the closing down of over 200 stone crushing units in Delhi and made them shift to stone crushers zone in the state of Haryana, as the quality of environment cannot be permitted to be damaged by polluting the air, water and land to such an extent that it becomes a health hazard for the residents of the area. Environmental Awareness Case 1992. The Supreme Court in this case issued directions for imparting environmental education and awareness in the country. This would include measures such as making environment a compulsory subject from classes 1 to 12 in schools, introducing environment as a subject in universities, mandating cinema halls, touring cinemas and video parlors to show slides or messages on environment, and ensuring programs on environment on television and radio. Delhi Vehicular Pollution Case 1994. In this case, the Supreme Court laid down for far-reaching directions for the Union government to counter vehicular pollution. These measures included provision of environment-friendly, lead-free petrol, compulsory fitting of new vehicles with catalytic converters, conversion of all government vehicles and public transport to compressed natural gas, and ban on flying of all commercial vehicles older than 15 years on Delhi roads. Bichri Case 1996. In this case, remedial action was sought for the harm caused by operations producing a certain acid. The court fixed responsibility on the errant industry and asked the central government to recover the expenses for remedial action, stating that the right to life of the villagers of Bichri had been invaded and seriously infringed. Coastal Areas Case 1996. Since the coastal areas of India have a unique and fragile fragile ecology and are being threatened by the mushrooming of hazardous industries, there are statutory restrictions on the setting up and expansion of industries, operations or process in designated coastal regulation zones. The state governments and union territories did not formulate coastal management plans as required by law. The Supreme Court in this case directed that this statutory requirement be met by all states and union territories, and that their coastal management plans be prepared within a stipulated deadline. Taj Mahal Case 1997. In this case, the Supreme Court ordered that no coal-based industry could operate in the Taj trapezium, an area of about 10,400 square kilometers around the Taj Mahal. The polluting industries were directed to switch over to cleaner fuel or to relocate outside the defined area. The central government and the state government were directed to develop a green belt around the Taj Mahal and to provide uninterrupted power supply to curb the use of diesel generators. Prawn Farming Case 1997. This case concerned the large-scale environmental degradation of coastal areas caused by aquaculture farming. The Supreme Court ruled that no shrimp culture pond can exist within the coastal regulation zone and only traditional and improved traditional shrimp farming can be carried on this area. Also, the central government was directed to constitute an authority conferred with all powers necessary to protect the fragile coastal areas. Thus, the Supreme Court has often spoken out in favor of environmental protection initiatives in क्षेत्रीय प्रदूषण मुक्ति संघर्ष समिति वर्सेस स्टेट ऑफ यूपी 1990, the Supreme Court reiterated that every citizen has a fundamental right to enjoy a quality of life. Also in the Subhas Kumar versus State of Bihar 1991 case, it observed right to live include the right to enjoyment of pollution-free water and air for full enjoyment of life. The above mentioned are just some of the cases in which the Supreme Court has made a significant contribution to environmental protection efforts. Besides, as it clear from the table, various high courts of India have also supported the cause of environmental protection raised by citizens as PIL, declaring it to be the essential ingredient of right to life. Table in the words of the Indian High Courts. Damodar Rao versus Municipal Corporation, Hyderabad 1987. The enjoyment of life and its attainments and fulfillment guaranteed by Article 21 of the Constitution embraces the protection and reservation of nature's gifts without which life cannot be enjoyed. The slow poisoning by the polluted atmosphere caused by environmental pollution and spoliation should also be regarded as amounting to violation of Article 21 of the Constitution. Atakoya Thangal versus Union of India 1990. The right to life is much more than the right to animal existence. The right to sweet water and the right to free air are attributes of the right to life, for these are the basic elements which sustain life itself. The 80s and the 90s witnessed the increased use of PIL as a tool for environmental protection in India. The ability to invoke the original jurisdiction of the Supreme Court and the High Courts under Article 32 and 226 of the Constitution is a remarkable step in providing protection to the environment. Moreover, the courts have widened the dimensions of the substantive rights to health and a clean environment. Other issues taken up by the Supreme Court as PILs include solid waste disposal in cities, disposal of hazardous waste, regulation of manufacture and sale of pesticides, depletion of groundwater in Delhi, closure of polluting industries along the Hooghly in Calcutta, constitution of coastal zone management committees, compassion to animals, privileges of tribal people and fishermen, Himalayan and forest ecosystems, ecotourism, land use patterns, development projects, etc. The high courts have ruled on several cases relating to ivory trade, legality of lease for mining in reserve forest, sale of birds in Bombay, etc. PIS have enabled the cause of environmental protection to be taken up by a wide spectrum of people in society, lawyers associations, environmentalists, welfare forums, and even judges. Green lawyers like MC Mehta and green judges like Justice Kuldeep Singh and Justice Krishna Iyer have made immense contributions in strengthening environmental initiatives. However, we must not ignore the inherent limitations of environmental PIL. Some of these limitations arise out of technical nature of the cases that demand an independent scientific machinery to assist the judges. Also, it may not be wise to over-depend on law and judges' interpretation, as this law depends on the sensitivity of the individual judge and his or her understanding of the environmental problems. In any case, it should be for the legislature and executive to take a lead in environmental protection efforts in the ordinary course of things. The difficulties of PIL are heightened by the fact that environment cases involve conflicting interests of different sections of society, often leading to difficulties in implementation. Monitoring of compliance presents a big challenge only if the environment favoring judgments of the courts are actually implemented in letter and spirit will there be de facto environmental protection. It was the end. It is the end of the audio number 14. Next audio number 15, we will begin from the point 4, institutional mechanisms of unit 9, state initiatives from the sustainable development.